Welcome to Smokin Bulls, the podcast about business, money, and lifestyle. I'm Tyler.
Dave.
And today we have the pleasure of being joined by Jandy John from Concentra Trust. She's here to talk to us about corporate executorship and whether or not it's right for you. So without hesitation, let's get into it. Jandy,
thanks for having me.
Yeah, thank you very much for being here. It's your first time on Smokin Bulls. So thanks very much for taking your time to be with us today. And maybe we'll turn it over to you for a little bit here, Jandy, and let you do a bit of an introduction of yourself and who you work for and the type of work that you do. And we can learn more about corporate executors and why it might work for people.
Sure, my pleasure, and thanks for having me. So my name is Jandy John. I work at Concentra Trust. I've had many years of working in the estates and trust world. From various financial institutions, from all the big banks down to Concentra Trust. Been a Concentra Trust for about 5 years. What people don't know about Concentra Trust is a smaller trust company, but it is a national trust company with offices in Vancouver, Toronto, Saskatoon. And we are actors in the fiduciary capacity as corporate executor. We act as trustee, and we help people, Canadians especially, settle their estates. We also help them in the planning processes. What I like about Concentra, it's a smaller trust company, so it really adds that unique people feel and the relationship feel when we talk to our clients. We want to help them while they're alive. We want to help them when they pass away, and to help the family with the legacies that they leave behind. My role specifically, I am in the business development. I'm the director of estates and trust, and I'm the person who talks to the families while they're alive, while they're doing their planning. So if someone walks in and says, I want to add Concentra Trust to be my corporate executor. And again, corporate executor, there are different roles for a corporate executor, but we can get into that later. Then I'm the person that they'll be talking to, and I will help them with their plan. I'll work with the lawyers, I'll work with their accountants, I'll work with the wealth advisory team, and then Concentra Trust is a part of that wealth advisory team, and I'll look at their wills, and if they're drafting new wills, then I will definitely look and talk to the drafting lawyer and to say, hey, there's an is when it should be an at. So that makes a big difference in administration. So ensuring that everything is really done right up front. So in the end, and when they do pass away, when it's time to administer their estate, the language is clear. The family has an understanding of who we are as a trust company, and they know what to expect at that time and how the process works. So that's my role in a nutshell and what I do with Concentra. I'm working with the trust company.
Okay, great. It's pretty common, I think, when people are writing their wills, it's really common to think of the closest family member that you have or a family member that has what they believe to be some financial knowledge, and they'll list that family member as their executor. So, what's the difference, I guess, being in this situation where they're listing a corporate executor. So if you're going to name a corporate executor versus a relative, what's the main difference? And is there, costs involved, I guess, for using services such as yours?
Yeah, of course there is. And I tell people this with a little bit of levity because I tell my family members, do not name me as your executor, because I'm going to be your worst nightmare as a beneficiary, and I don't want that role. A lot of people consider being an executor as an honor, and there is a time and a place to name an individual. I mean, if we took back an executor and what it needs to be an executor, I've been doing this for many years, and it takes about 3 years to sell an estate. It's about 300 different tasks to do to complete an estate administration. The first task is locating the will. The last task is ensuring that CRA has clearance certificate for final distribution. So there are instances where a corporate executor makes sense, and there's cases where individual makes sense. So if a husband and wife are out there, spouses are out there, partners, and they have everything joined together, it makes sense for each other to be their executors. If the estate is being left to one person and that one person is the executor, that makes completely sense. But if there are other complications to add, if there's property to be sold, corporate executor makes sense. And the various roles a corporate executor can fit into their planning scheme. They can have a corporate executor as the alternate. And by alternate, I mean it's a backup, it's an insurance, just in case the person that they assign as executor is incompetent or cannot complete the duty as acting executor. Because remember, when we name someone as executor, doesn't mean that they're going to act. They can say at the end, I don't want to do this, especially if they didn't know about it. So naming a corporate entity as the alternate to the person you're being named, it makes sense in terms of to carry on if something does happen to that name executor. I know I talk a lot, but I can talk about this forever.
This is good, though. This is good. I mean, the one thing Tyler and I always mention to our clients is there's no glory in being an executor. This is going to be, like you said, a nightmare, and your siblings or whoever the other beneficiaries are, their ideas, well, just why haven't you paid me out? Where's the money? What's taking so long? You're manipulating this. You're starting to play around. You can change beneficiaries, all this stuff. It's not pleasant. Yeah.
Exactly. I want to also answer. I didn't answer the part about cost. An executor, whether it being a corporate executor or an individual appointed, they can charge a fee. The standard is 5% of the estate value. That's the standard. That's what the courts typically approve for executors' compensation. And again, there's measurements that's too technical to get into, and how you measure if the court is going to approve it. But a corporate executor, because there's volume around and an infrastructure set up, they tend to charge significantly less than that 5%. So most trust companies will start at the 4.25% and scale down depending on the size of the trust, the estate to administer.
Great. Yeah. And so I think for when we talk to our clients too about this, the explanation is that is the fee for the corporate executor. But any costs that are out of pocket for the corporate executor are charged to the state as well. If you're maintaining properties for them, if you're acting as, anything, there's a cost being charged to you, which you pass on to the state.
Exactly. And it's the same thing that an individual executor will do also. If there's real estate to secure, you may need a property manager. So the property manager will cost, and it will go back to the estate. Any expense of the estate, regardless of who's administering the estate, is never going to be out of pocket for the executor. It would always go back to the estate. Legal fees, the cost of preparing the tax returns, property management, and even if there's advice needed for the estate, if there's ambiguity in the terms of the will, they may need some legal advice for interpretation. That goes back to the estate itself.
Okay. Well, thanks.
When people list a corporate executor, it sounds like there's a couple of situations where you would consider it, and it's when you said there's the final spouse, or so you'll only have one spouse remaining. Yeah. And the second situation you indicated was if they had other properties. Are you talking properties like homes, so second homes, or are you talking properties like investment property or assets like that, or both?
All of the above. The beauty about corporate executors too, you can have the corporate executor acting solely. So if, for instance, if my husband, we're fine, and we look at each other and say, I don't want to settle your estate. He says, I don't want to settle yours, because we do have assets that are separate also, and not everything is joint. So a corporate executor is going to come on as sole executor. They're going to administer my estate. They're going to administer his estate. But if I say now, okay, husband, I want to administer some of your estate. So I'm going to be joint with the corporate executor. So there are different ways to appoint the corporate executor also. A lot of trust companies do have minimum values in terms of what they're going to administer. And traditionally, it's about $1 million. But Concentra Trust itself, the value is a little bit lower because we want the service to be for all Canadians. So we have a different minimum threshold in where we want to look at. And we want to, because we're about creating relationships also, we want to have those conversations. And if it's the best fit, yes, it's the best fit. If it's not the best fit, it's not the best fit for corporate executor. But having those conversations and realizing what it's going to be, because with corporate executor with minimum fees also, you want to make sure it's the best fit for the clients.
Right.
I would think, I mean, where there's hundreds of situations we could discuss and why you would want a corporate executor, but not the easiest one that we talk to clients about is when you have a few beneficiaries and there's a sense that they might not get along. The other would be co-executors and they're living in different provinces. Now you're starting to move between lawyers and a lot of legal problems. So that's kind of the ones that we touch to. Kind of what you see a lot of.
I see a lot of those and beyond. We have a sheet of when a corporate executor makes sense. We all know that people think that their families are wonderful and they get along in life, but sometimes they don't get along in death. We all like money makes people change dramatically. So if there's complex family dynamics, and there's a lot of things to define complex, do they get along? Are their siblings, do they argue? Do they get along? Do they fight over the smallest of things? Do they have estranged marriages? Do the children have estranged marriages? Do they have blended family situation? That's blended family, or is it a second marriage situation that needs a third party to be completely neutral in the division of assets? There's residency also, living out of province, living out of country. We live in a borderless global world at this moment where people tend to move over. Myself, both of my kids don't live in the province anymore. So we need to understand that if they don't live in the province, it changes the complexity and it changes the tax of the estate itself. So we look at that also. And one of the biggest things too that people need to understand is, do they have the expertise to manage this estate? Like estate administration is not just about cutting a check and paying it out. There's a lot of different things that needs to be understood. There's the legal side of things, and you need to know enough to recognize, when do I need to call a lawyer? You need to understand investments. When do I sell these? Do I keep them in forever? I'm working on a case right now. The person died in 2019 and the assets have not been sold. So that executor is going to be liable because the market has crashed, right? So that executor now is going to be liable for all that loss because they did not make that decision in time. So it's just understand what needs to do and knowing just enough to know when to call an expert in.
Yeah, I mean, I wrote something here, and I don't think we could. Maybe you have the answer to this, maybe you don't. But what percentage of Canadians ever will act as an executor in their lifetime?
Oof, I don't have the answer to that, but I know 52% of Canadians don't have wills. So.
Yeah. There you go. Yeah. You occasionally run into that person who's been the executor on like 3 or 4 wills, and you're like, okay. So it's an honor thing for that person to step up, but it's not a great job though. So I think, for us, when we deal with our clients, you're way more of an expert on this. We dumb it down a bit, I think. And, we always look at it when you have a few beneficiaries that are siblings and you think, your guys are pretty good with each other when the parent is there, but it's kind of like taking the referee out of a hockey game. Once the referee's gone, all bets are off, so it's game on.
Great analogy. Wonderful analogy. That's exactly what it is. And if those children have spouses and the voices of the spouses are now being heard, I mean, it's again, I've lived it so often that I've become cynical with it at times, and I know I shouldn't be, but just by lived experience and seeing it just unfold. What I find really work with families, though, is having that conversation while you're alive. Set the expectation for the children. I know I sit with my kids and they don't want to talk about that, but here's what's going to happen. Here's what we have in place, making that plan. So I think that helps a lot, too, is those conversations with the family.
Yeah. I mean, ultimately, it could be like a good Hollywood movie. There's one person on one side of the table. There's 3 kids. You push 3 envelopes. They all look at the envelope. They all look at each other, and they don't know who to be mad at. They don't know each other. So.
Oh, so great way of looking at it. Fantastic way of looking at it. I can tell you some stories about fights I had to just stand in between, but it's not the time for that one. Yeah.
That's good.
Yeah.
That would be exciting.
So how hard is it to list a corporate executor? Is it as simple as you're listed by name as a corporation in the client's will? as
That's
executor?
exactly it. That's exactly it. It's in the will, and it's listed as the corporate entity in the will. And if someone is listed a corporate executor, have the corporate entity review that will before they sign off on it, because there's certain language as a corporate executor you want to see in that will. And it's the naming of the corporate entity itself and some other clauses like a compensation clause, an investment management clause, and also having clear direction in that will. Also, I've seen wills where the administrative clauses were not really clear, and there was a lapse in who's the beneficiary. So, and as a corporate entity, you want to make sure that's done right up front, so there will be less cost in the back end. So the short answer is yes, it's named in the will.
So would Concentra be the one providing the wording to the lawyer to say, hey, can you please enter this into the will?
Correct.
Not the lawyer creating the wording, but you guys creating the wording.
Yeah, we have specific clauses we want to see in the will. The lawyer will work with the client also to get what they want to happen in terms of to get test competency, making sure that they have their instructions. And then we look at it and then we put the Concentra Trust clauses, we call them, into the will to ensure that they can be administered correctly.
And I think you touched on it earlier, Jandy. If somebody's been listed as an executor and they're overwhelmed by it and don't want to take that on, they can come to you guys and say, hey, I'm going to hire a corporate executor to handle this. It's not going to be me. So do you see a lot of that? Or?
Yeah, I'm seeing a lot more of those actually. After the pandemic, throughout the pandemic and after the pandemic, a lot of those, we call that service agent for executor. The executor is named, the executor looks at it and says, you know what, I'm going to act, but I don't want to do the task. I don't want to do all of the work in this. I don't have the time nor the capacity to do it. And they will hire the trust company to act as their agent for, and then the trust company will settle the estate with, while settling the estate, though, you'll ensure that the executor still has the final say, because they're still responsible for the administration. It's just delegating it to the trust company to complete the task.
Yeah. So if they've delegated a trust company to complete the task, I assume the liability of things still fall on them as executor. How do you help mitigate that liability? How do you explain what liability Concentra Trust is going to absorb in acting for that executor?
Although the executor is still liable for those liability, they hired a professional to do so. It's like if I'm building a house and I hire a contractor and something in the house falls apart, I own the house, but the contractor is responsible. So the liability in essence comes back to the trust company, because we are the professionals. This is what we do. We advised in a fiduciary capacity. So that liability does come back to the trust company. If we're hired as an agent for executor and we're advising the executor, for instance, we said, do not distribute, you do not have clearance. And the executor says, no, I'm going to distribute. And we say, no, you should not distribute. And we put it in writing because you do not have clearance. We know it's wrong to do that. We're going to step away at that point, because again, that liability will explain the liability. And if they're insistent on doing such, then we'll explain everything and the liability and why you shouldn't doing it. 10 out of 10 times the executor will listen, because we're going to explain to them why they shouldn't do what they want to do in that case. But if they want to go ahead, we'll have to remove ourselves from that situation.
Okay, so I mean, once again, I'm going to ask questions that maybe there's no numbers for this, but what would you say on average, it takes an individual in Canada time-wise to settle an estate compared to using a professional like yourself?
I can give you examples based on my experience, and I've seen estates that I'm dealing with one right now. She approached me a year and a half ago, and she said she's going to go and do it. She hasn't even done probate application yet. So it does take significantly long. I want to say twice as long. For a corporate entity, it will take about 24 months to 36 months. And that timeline is based on waiting for CRA to issue your clearance certificate. So a lot of that is the waiting for that process. For an individual, I want to say double that because again, and then there'll be a lot of steps left out because what we see come back to us after is things that were not done. And then it's trying to clean up what was not done. So I want to say double the time, maybe 4 or 5 years they will take to settle in at a state, properly settle in a state.
Yeah. And you've alluded to this and made a comment like being a corporate or not a corporate, just a personal executor, there's a liability there. That's why you're getting paid technically. But when you drag the timeouts and maybe because you're busy or you don't understand or you know all of those things, the beneficiaries could come after you eventually for taking too long. Your example of you never sold assets and they've been sitting there and now it's a down market and now it's time to wrap the estate up. Like I mean over the years I've heard people where it's never been wrapped up. We're 10-15 years and it's just sitting there, and somebody's just running a portfolio the state of, and you're like, why is this not gone?
Yeah, and it's a huge liability too, especially, and executors, although they have their decision makers, they're not in control. The beneficiaries are, because, and again, from what I see is beneficiaries will sue and they will complain because they're not getting information. And in most cases that comes to us after for the cleanup is because it's a lack of transparency and communication with the beneficiaries. You're right, I've seen assets sitting for 10 years. Sometimes it goes up and they're clapping their hands and it's fine. But when it goes down, that beneficiary has to write a check to cover the difference because those assets should have been sold in this state.
Yeah. Yeah. And there's a misconception as well that that someone who's the executor, has this power to alter the will and change who gets what. Struck a nerve, Jandy.
Yes. I mean, I've seen some things in my lifetime and I've seen some situations where I didn't want that person to have it, so I didn't give it to them. What? The will is the final voice of the will writer. You cannot change that after they passed away. There's no way to do that. You can't even go to court and have a judge bury that. So, seen that so many times.
It's a power thing for some people. Sometimes it's an honor, sometimes it's exertion of power. But that also goes back to maybe lack of planning by the parents or the will writer. That they didn't really discuss this with the kids. And like you said, it's kind of a taboo subject. We don't want to talk about our death or our passing, but those that do, and those that do a lot of planning, that's a good thing, even though the kids might not want to hear it or the beneficiaries. But we have these conversations with our clients, and we do kind of promote using of a corporate executor just for the clean movement of things and to maybe just take it off the plate. Maybe your kids do get along and they're great with each other, but why chance it?
300%. And if it can even add the corporate executor with the children to be that neutral party, right? So children can still be involved, and then add that neutral party, that's referee, if to the opposing sides of interpretation. And that makes it easier for everybody in the long run. I tell people this all the time, and it's become my mantra. The only thing that's guaranteed in life is death. That's the only thing that is really guaranteed in life. And the absence of if there's no plan, that's the worst estate plan that you can do, is having no plan in place. Because you hear a lot of the government will take my money. Oh, my children will get it. That doesn't happen. There are rules to everything, and there's rules for your money after you pass away without leaving a will.
Yeah. We did a lawyer we worked with many years ago, and I don't know if he wrote it himself or if it's just one of those things that are passed around lawyers, but he wrote up the intestate will with some humor in it, like it was basically, well, you know what? I don't want to be known as a complicated person, so I want my beneficiaries to fight over who's going to take the role as executor. And, so it was pretty good based on Alberta rules. It's kind of neat. So we do pass that out every once in a while when people don't have wills, and we're like, this is what happens if you don't have a will. So that's kind of cool.
I like those stories. I once had an estate where the will wrote, please attend my funeral. And if that person doesn't show up my funeral, they do not get in the will, they do not get the gift. And I had to sit there and write who entered that funeral. Like I couldn't, because you can't control from beyond the grave, but it was just interesting to see how people's mind works.
Yeah. And even the fact that you got to update these wills more often than people do. I mean, things change, people's lives change, but they're just life events, and people don't see them as kind of will events. And I remember rewriting my individual will when I got married, and of course I had in there, set aside $10,000 and $2,001 for a party. While my wife's looking at this going, do we still need this? And I'm like, as long as you take care of things, we don't need it in here. So that got removed, so fun stuff like that.
The rule of thumb is usually 3 to 5 years, or a life-changing event or a life event. And define your life events. If you move provinces, if you have a child, if you get married, if you get divorced, death of a spouse. So the rule of thumb is take it out, shake it off. Does that still make sense? If it does, tuck it back away. If it doesn't, I need to amend. So yeah, I tell people, put it out 3 to 5 years.
Yeah. I think because of the age of our clients that we deal with, for the ones who never had a will, they tend to write their first will when their spouse dies. It tends to be part of that whole process, settling that part of the estate. And it's like, okay, I've got to write a will now, because it was either or. Now it's the definitive. This goes to our beneficiaries after I pass away. So it's interesting to see that's a catalyst. Someone has to die for someone to realize they need a will. Yeah. So
yeah. Well, at least they had, if their assets were joined to one, it went one to the other. There's not a lot of complications there, but lo and behold, if there were separate assets, then it would be a whole different thing.
Yeah, it's this is part of the estate plan. This is part of the financial plan. And I just think of all the situations we've seen that things didn't go right. And depending on the province, depending on the rules, we had a client pass away and the spouse had the house in their name only, but they were in a province where, they had to pay a probate fee to settle the house of $18,000. Yet they've been married for 25 years. Like it was just, put it in joint title. It's crazy.
Yeah, it's the simple things we do in our lifetime too that helps in the end. And when a loved one passes away, that grieving process is so emotional that sometimes it just takes away from the rational side, and we don't need to start thinking rationally when we're grieving. So just look through your. And you guys probably do this with your clients too. Is look through their finances. What do they have? How can they change things? Their RSP register plans, are they designated beneficiaries? Are they going to the estates? Like just things that we can look at in our lifetime to make it a little easier to transition when we have to do our grieving.
For sure. Mm-hmm. Sure.
Well, that's excellent, Jandy. Is there any other comments you want to put out there to people that might be considering this?
Yes. I'm a big believer in having a plan. Have a plan in place. It helps financially, emotionally when it's time to sell an estate. And when we talk about estate plans, look at the holistic estate plan. Think about power of attorneys. Think about your will. Think about, do I need some kind of trust structures in my life to make sure that I have some privacy in things, right? So think about your whole picture and what it means and how it means to your family, what you're leaving behind and who you're leaving behind. Do they have the expertise to deal with what I'm creating in my lifetime? So look through all the plan and think of the whole plan holistically, because the absence of a plan is no plan, and that's very costly when you pass away.
Good. Yeah, good comments. Yeah. Well, thank you, Jandy, for your time today and joining us here on Smokin Bulls. We look forward to having you back perhaps again in the future sometime. If we want to learn more about Concentra Trust, Jandy, is there a place to find you guys online or?
Yes, there is. We have a new webpage, concentratrust.ca, and you can contact me directly, jandy.john@eqbank.ca. Because Concentra Trust is owned by EQ Bank.
Great. Okay, well, thanks again for joining us. And if you want to learn more about us, follow us on our socials or check us out at smokinbulls.com. Thanks again for watching, and thank you again for being here, Jandy.
Oh, my pleasure. Thanks for having me.